Welcome to the New York State Notary Association Refresher Training, August 2016. This month's topic will be professional conduct. Use of the Office of Notary Public and other than the specific step-by-step procedure required is viewed as a serious offense by the Secretary of State. Breaking the specific step-by-step procedures outlined in the Notary Public License Law can result in a loss or suspension of license and the criminal charge of professional misconduct, which, if convicted, is a Class A misdemeanor with a definite sentence to 1 year maximum in jail. The simplest form in which any oath may be lawfully administered is, quote, "Do you solemnly swear that the contents of this affidavit subscribed by you is correct and true," end quote. Alternatively, the following affirmation may be used for persons who conscientiously decline taking an oath. This affirmation is legally equivalent to an oath and just as binding. It is, quote, "Do you solemnly, sincerely, and truly declare and affirm that the statements made by you are true and correct?" Unless a lawyer, the notary public may not engage directly or indirectly in the practice of law. Let's cover some of the activities involving the practice of law which are prohibited and which subject the notary public to removal from office by the Secretary of State and possible imprisonment, fine, or both. Of course, that's called a tribunal hearing, and you're given a copy of the charges against you and an opportunity being heard. Now, I have a warning here. We cannot cover all the illegal activities today, so you need to be familiar with the statutes, and we recommend highly that you download a copy of the PDF formatted version included in the email newsletter. If you're not receiving the newsletter, you can subscribe for free at www.notarypublicnewyork.com. Of course, there's all kinds of downloads in there and other refresher training videos and benefits to the members. Number one, you may not give advice on the law. The notary may not draw any kind of legal papers such as wills, deeds, bills of sale, mortgages, chattel mortgages, contracts, leases, offers or options, incorporation papers, releases, mechanics liens, powers of attorney, complaints, and all legal pleadings, papers, and summary proceedings to evict a tenant, or in bankruptcy, affidavits, or any papers which our courts have said are legal documents or papers. Now, those of you listening to this probably never heard of most of those things, but some of these items may affect you as individuals where you work. One thing we're not allowed to do is we're not allowed to marry people in New York State. We're not allowed to notarize contracts of marriage, whereas a notary, for example, in Florida can marry people by notarizing contracts of marriage. So the Notary Public License statutes, unlike a driver's license, which can be transferred from state to state, are dramatically different statutes or laws, different rules and procedures, and you get in a lot of hot water following another state's rules in New York. So number two, you may not ask for and get legal business sent to a lawyer or lawyers with whom you have any business connection or from whom you receives any money or other consideration for sending the business. What is consideration? Well, the definition under the Notary Public License Law statutes for legal consideration is this, and I quote, "anything of value to you, including money, services, and love and affection," end quote. So anything that you might value that you receive for sending business to an attorney from an attorney is illegal, and it's in effect criminal contempt, which is practicing law without a license, which is a Class A misdemeanor, which is a definite sentence if convicted to 1 year maximum in jail. You may not divide or agree to divide fees with any lawyer or accept any part of lawyer's fees on any legal business. As we covered in last month's video, notary publics that are in ethnic neighborhoods where they speak different languages must put up signs in those languages stating that they are not an attorney, because we covered that in most other countries to be a notary public you're somebody who went through law school, whereas in New York State you don't even need a high school diploma to be a notary in the state. Number four, you may not advertise in or circulate in any manner any paper or advertisement or say to anyone that you have any powers or rights not given to you as a notary by the laws under which you are appointed. Is that saying you can't advertise and let the whole world know that you're out there offering, for example, traveling mobile notary services where you can charge $100 to travel to somebody on a Saturday morning. No, you are allowed to advertise. But don't advertise, for example, that you could marry people or draw legal papers or do wills, because those are considered illegal in New York State. Now, to make it a business to practice as an attorney at law, not being a lawyer is a crime. Counsel and advice, the drawing of agreements, the organization of corporations, and preparing papers connected therewith, the drafting of legal documents of all kinds, including wills, are activities which have long been classed as law practice. This includes wills. No will preparation in New York State. The Notary Public License statutes quite clearly state that if you notarize a will without an attorney's license, you can be charged with criminal contempt because you are in effect practicing law without a license. Now, for those of you that were lawyers in other countries and came here and got your notary license, assuming you'd be able to resume these things that are considered practicing law in New York State, you cannot do these things with just a New York license, even if you were licensed as an attorney in another country. In New York State, to practice law, you have to pass the New York State Bar exam and get licensed. So, executive law in New York states that misconduct by a notary and removal from office can in effect happen. A notary public who, in the performance of duties of such office, shall practice any fraud or deceit, you're guilty of a misdemeanor. Executive Law 135A covers that in your notary license law statutes. And you may be removed from office, of course. That's after you've had a copy of the charges against you and an opportunity being heard. It's called a tribunal hearing. The notary public may be removed from office if the notary made a misstatement of material fact in his or her application for appointment, and for preparing and taking an oath of an affiant to a statement that the notary knew to be false or fraudulent. Now, are we supposed to know when we notarize people's signatures on affidavits if the statements they're making are true or not? No, we're not. This is when you know something's not true and you notarize it. That's probably because you had a conflict of interest. So this can also result in Class E and D felony convictions. Class E felony convictions are minimal sentences of 3 to 7 maximum if convicted, and an E is 3 to 4, and a D is a minimal of 3 to 7 if convicted. When the notary public participated with an intent to deceive, injure, or gain a benefit. Once again, a notary is not guilty of notarizing something that is not true when you don't know it's not true. But if you were so involved in that and you help perpetuate a lie, you're really fooling around with some dangerous fire there. So Martha Stewart's a very famous person that got a felony conviction for lying under oath, which is perjury, and a felony is no joke in New York State. So, to get signed up to have the free monthly newsletter emailed to you, and for Notary Public License info, if you're not licensed, please visit www.notarypublicnewyork.com. That's it for the August 2016 video newsletter. We hope you're enjoying your summer. There's a few more weeks left. Enjoy it while you can. We'll see you next month.